this new law that was passed in December, the biggest change that it caused was imposing a much larger criminal penalty against mainly government officials, but anyone who would release information that has been designated as secret. A government official or someone else who releases designated information may be subject to up to 10 years imprisonment. So there will clearly be an effect, I mean, there will obviously be an effect on any government official who thinks about the kinds of information he can talk about when he's meeting with reporters or when he otherwise is discussing government actions or government policy. So this law is a threat to officials who may decide to release information that may be designated. There is no whistleblower protection provision provided. So if, for example, if an official is exposing improper activities, if the official is exposing bribery or some other form of improper action, it won't matter. If the law simply says if there's a disclosure of designated information, that's a violation of the law. Under the Japan's law, there's no requirement that the government in a prosecution show that there's any damage to the national interest. There's no protection provided when a person is acting in the public interest. There's no protection provided for journalists when prosecutors make the decision that they're acting improperly. The law also provides up to 5 years imprisonment for someone who may induce the release of designated information. And of course, the very job of the investigative journalist is to dig, is to really persuade sources of information, to disclose information which is of great public interest. So under this law, journalists may potentially face up to 5 years imprisonment if they report on a story that relies on some information that has been designated as secret. In the United States, we often say that no journalist has ever gone to jail for reporting a government secret. And of course, we talk about the Pentagon Papers case, and we talk about other famous cases in American history. In Japan, there's only one case, one important Supreme Court decision related to this problem. It's called the Nishiyama case. And in that case, the Supreme Court of Japan upheld a conviction of a reporter for, at that time, Japan's biggest newspaper, the Mainichi Shimbun, for reporting, actually disclosing government lies related to the return of Okinawa to Japan. That is the only relevant precedent that we have from the Japanese courts on the relationship between the constitutional guarantee of reporting and free speech and the government's legal authority to maintain secrets. The action by the Supreme Court opens the question of in what cases will the courts decide that the actions of a reporter are improper. You know, if we think about a very famous case recently from England, we had a newspaper where the reporters were tapping the cell phones, right? They were violating the privacy of the users of cell phones to gather hot information based on stories. So we think, well, they were reporting stories of public interest, but they were not only acting improperly, but they were actually breaking the law. And I think most of us would agree that even though the reporters are protected by the freedom of the press and the right of free speech, that they are not thereby empowered to take actions like that that cause serious breaches of the law. In Japan's case, if we look at the statute that was passed in 2013, we have some very elastic language in the statute that says that freedom of reporting will be recognized if it's not inappropriate. And we don't have any definition for what may be appropriate, what may not be appropriate. So we'll rely on future prosecutors to decide when they've uncovered a case and they think that some improper activity has taken place which violates the law. And when they think about that, the only precedent, if they think, what have the courts decided? The only precedent they have to look to is the Nishiyama case. And of course, the people rely on journalists to investigate stories, to report, to provide that information. Almost all of us rely very heavily on the news media to learn about the actions of government. So to the extent journalists are investigating stories and they come into contact with information that may have been designated secret, and of course the reporter won't know. The reporter, as part of his job, will be interviewing government officials, former government officials, others who have access to information, and will be trying to uncover stories that are of public interest. In the course of that process, the reporter bumps into information that's been designated secret, then potentially that reporter could be prosecuted. If we don't have clarity in the regulations, if we don't have clarity in the law, then we don't know what is the extent of government's power. We don't know how government agencies will use that power, to what degree, to what extent, what range of information may be covered. And keep in mind, this problem is not unique to Japan. We have a very serious problem in the United States for decades, literally. Anyone who's analyzed the US system has said the most serious problem we have is overclassification. There's just too much information is designated as secret. And to the extent information is designated as secret, it means the people can't know about it. It's hidden. The government is acting based on information, it's making decisions, it's taking actions that we don't even know about. If we have a democratic government, if we believe that people really are sovereign and they have a right to know about what government is doing in their name, then when we think about the kinds of information that should be maintained as secret, we have to think very carefully about what the rules are that result in the secrecy designation, at what time information that was secret should be released, what procedures may exist for government officials or individual people or anyone else to challenge those secrecy designations, and so on. The Tsuwane principles were adopted in June of 2013, following a process of about 2 years, which involved former government officials, academic experts, NGOs from around the world. There were several meetings held around the world. There was long discussion of individual principles, and they were adopted in June of 2013. So one of my biggest complaints about Japan's parliamentary procedure was they didn't consider the Tsuwane principles at all. It was as if they did not exist. If we think about the United States, there really is I think we can say robust. There certainly is a well-established procedure, and there are government agencies who are really charged with declassifying information, and various presidents have issued executive orders which have promoted a process of taking former secrets, declassifying them, and making them available to the public. There's even a procedure that allows individuals to identify specific types of information and request declassification. And in fact, the data shows most of those requests are honored. And I haven't investigated this carefully, but I assume most of these requests are filed by historians and researchers who are doing research in the area. And as I said, most of those requests are actually honored and the information is disclosed. Japan has no history of any such procedure. There are no institutions that have been established that are charged with declassifying secret information. There is not a significant community of historians and researchers who are experienced in ferreting out this kind of information and who have had the benefit of some formal procedure. There are not a series of court decisions that have addressed these kinds of issues. So you think of this entire kind of infrastructure with how to handle the information, how to handle declassification, create a process so that information will be released. It just simply does not exist. The experience we've most recently have, which is most instructive, concerns a revision to the Self-Defense Forces Act, 2001. That revision to the law created a new category of secrets called defense secrets. And according to reported information, over a period of several years in the mid-2000s, there were tens of thousands of designations of information as defense secrets. And if we ask, well, what happened to those secrets after a certain period of time elapsed, according to the published reports, there was only one example of a defense secret that was actually declassified and then released. The overwhelming majority of those secrets, when the period of secrecy came to an end, were simply destroyed. So there is no historical record of what happened, what information was designated secret. It's all gone. The secret documents that were revealed by Mr. Nishiyama, there are copies of those documents available for public viewing in the National Archives of the United States, the so-called NARA, the National Archives and Record Administration in Washington, D.C., has copies of that information. It's been discovered by Japanese researchers. They fly to the United States, they do their research in American archives, and they discover all kinds of information that's not available in Japan. Why is it not available in Japan? Well, there's several reasons. First, a lot of information has simply been destroyed. We know that vast amounts of information were destroyed at the end of the war, or perhaps even during the war. We know that vast amounts of information were destroyed in the years leading up to 2001. 2001 was the year the Japan's Freedom of Information Act came into effect. We know that many, many ministries destroyed large volumes of material in the lead-up. Prior to 2001, there was no legal right for anyone to request information for the government. So to prepare for that new law, they destroyed lots of information. So we know government archives are valuable. We know our researchers and our historians absolutely need them. In Japan's case, a lot of information has been destroyed, but not all of it has. So we do know, for example, that Japanese historians have uncovered government documents related to the creation of the comfort and operation of the comfort women's system, so-called comfort women's system. That's one example of many that have been uncovered because there still is information remaining in the Japanese archives. We lawyers, of course, always think about the Constitution. The Constitution's the supreme law of the land. And when we think about Japan's Constitution, or if we think about the American Constitution, it's very old. It's 220 years old. And of course, we treasure that Constitution. We all study it, and we argue about what it might mean, but there it is. And it's been modified many ways, but the fundamental provisions, the guarantees of individual rights, they have been unchanged. The wording in that Constitution has essentially been unchanged. To the extent it's been changed, it's been expanded. Then if we look at Japan, of course, the history of Japan's democratic constitution is rather short. It came into effect in 1947. Now it's 2014. The Prime Minister of Japan is a man named Abe Shinzo. And Mr. Abe, throughout his career, has been a very strong advocate for severely changing that constitution to dramatically weaken any protections for individual rights. Mr. Abe and the Liberal Democratic Party have never advocated greater government transparency. Japan does have it does have a freedom of information law, but it's a very weak law, and the Liberal Democratic Party has always opposed expanding it. Most recently, if we think about global comparisons, Mr. Obama, after he became president, became the sort of the prime mover of a global initiative called the Open Government Partnership. Today, the Open Government Partnership has been joined by more than 60 countries, including most of the major democracies of the world. And the Open Government Partnership is an agreement among governments to promote more openness, to expose more information to the people, to provide more opportunities for people to participate in developing government policy. Japan's government has absolutely refused to take part in the Open Government Partnership. It's absolutely refused to even begin to prepare, to seriously consider participating in the Open Government Partnership. The 2013 Secrecy Law says if the information has been designated as a secret, then release of that information is a crime. Was it properly designated as secret? Would the release of that information actually endanger national security? Those questions are not relevant. The only question under the law is, was it labeled a secret? If it was labeled a secret and you release it, you've committed a crime. And there is no protection for whistleblowers who may be acting in the public interest.